And last one is business marketing. And you see this picture. This is Bob. Bob, he has a kite. So when I think of Bob having a kite, what does he do? Well, if he's a sole proprietorship, Bob has kites. But what is he doing? Is he collecting them? Is he, selling them? Is he, inventing new wonderful ideas with kites? I don't know. Basically, Bob has kites. That's basically a sole proprietorship in my mind. Basically, we don't quite know what he does. Basically, he's just holding out his shingle as far as Bob's kites. We don't know what he does. Then we go into, then Bob decides that, you know what, I want to actually sell kites. So, but then he forms Bob's Kites LLC. Now, I might be a little bit jaded, but when I think of an LLC for an operating business, if you're doing something, I think of it more as a hobby. I don't really take you that seriously. When I think of LLC, and I'll get into this in a second, but when I think of LLC, I think of hobby. But then Bob decides that, you know what, I'm killing it. I'm making a ton of money. I want to incorporate. So we got Bob's Kites Inc. Now, when I think of, again, because I've been in business for quite a while, I mean, I deal with corporations all the time. But when I see the Inc. or the Co. at the end of a business name, I think of a serious player in the business world. I think that this guy knows what he's doing. I don't know if he did it or not, but Bob, could be selling kites in China, and that's where kites were invented. But I take him a lot more serious because he had the wherewithal to incorporate. And here's my little soapbox on why I don't like LLCs, especially for people doing it on their own. Thing about LLCs is that they're too simple. Everybody has one, so nobody thinks about them. Usually when I think of LLCs, I think of somebody say, I want to start a business, and they talk to their neighbor over the hedge, and the neighbor goes, oh, I've set up an LLC, or my brother-in-law has an LLC. It's really easy to do. All you do is just file a certificate of formation, you're an LLC. Well, because of that, they become so ubiquitous here. Everybody has one, but because everybody has one, nobody really takes the time to figure out what goes on into operating them. The structure is too loose. Most owners don't have an operating agreement. And I mentioned earlier that the operating agreement are the internal rules of the LLC. Now, how is it managed? How is it operated? How are things allocated? What is the tax consequences of doing certain things? Most people don't have anything like that. They're just kind of flying by night. And even if they do, they don't know what the rules are or what they mean, so they don't follow them. They just think it's paper, and they don't follow the rules. And because of that, we get into the alter ego theory of LLCs and corporations. Because owners don't follow their own rules, it's easy for creditors to claim that the LLC is just an alter ego of the owner. So the LLC structure is disregarded, and the owner is held liable for the debts and liabilities of the LLC. Again, going back to owners buying groceries with company funds. Basically, is the LLC truly in existence, or is it just a paper thing? Because you took that little sheet of paper you get from the Secretary of State saying you are an LLC doesn't really mean a whole lot. You start commingling assets. Now, I mentioned an operating agreement. Now, with operating agreements, you can actually elect to do certain things outside of what the default rules of an LLC are. Prior to 2016, Washington's LLC rules were actually not that bad. But in the Washington legislature, in its infinite wisdom, decided to make things simpler. So now, for example, voting now does not follow ownership. Before 2016, voting power followed ownership percentage. So if James owned 99% of an LLC and I owned 1%, James had 99% of the voting power. That was the default rule. But now, after 2016, we form an LLC. James may put 99% of the equity in the business, and I only put 1%. But absent anything in the operating agreement that we have, the voting power is based on the number of owners. So one person, one vote. So if James has one vote, I have one vote. That is the default rule. Secondly, operating agreements do not need to be in writing. That was kind of inferred, but now it's expressly stated in the statutes on LLCs that oral operating agreements are now expressly allowed. And we as attorneys hate this because it can lead to confusion, mistake, or ambiguity. Now, James and I form an LLC. Things are going great year one, but who's to say in year 5 when things start turning south? And then we get into a he said, she said situation about how we're operating the LLC and what we decided 5 years ago. And that's why I don't like the default rules, because you don't, if you follow the default rules and don't do everything, with a purpose, then you're probably going to get into some bad situations. So my recommendation on this is opt out of the default rules and see an attorney to discuss what your options are about how best to make sure that things are taken care of now, as well as 5 years from now, 10 years from now, things like that. And I'll now get up my soapbox. So my recommendations going forward as far as LLCs go, I like LLCs for holding stuff. If you're holding real estate, like I have a new client that actually has 7 residences that rentals that he's renting out. Those should go into LLCs. Investments, holding investment property, investments, stocks, bonds, things like that, hold that in an LLC. Intellectual property is a huge one now. If you have an idea, put that into an LLC. Now, real estate, you always put real estate into an LLC, because if you put into a corporation, bad tax consequences could happen. But everything else, if you're just holding stuff, put that into an LLC. If you're just starting out and you don't have all the resources to pay all the costs associated with a corporation, set up a corporation, you need to set up payroll. That could be expensive. You should probably get a bookkeeper. That could be expensive. CPA to do your taxes. That could be expensive. If you don't have don't have the resources, capital to kind of finance all this stuff, then maybe an LLC may be a better way to go just to start off. You need flexibility. You have multiple partners that require different allocations of income, or et cetera. You need to have that flexibility in moving income distributions out among the partners differently than what their ownership truly is. LLC is a better way to go. Or if you can't be an S corporation, if one of the owners is a corporation, LLC, trust, estate, or non-U.S. citizen, you kind of hit that barrier where you have somebody that can't be an S corporation shareholder, can't be an S corp, which makes that you can't be an S corporation. That's when you go with LLC route. Now with the S corporation, I like S corporations if you're doing stuff. If you're doing an active business, if you're selling, if you're providing services, especially in a high-risk business. I mentioned marijuana, cannabis. I have a couple clients like that are actually engaged in those high-risk activities. I highly recommend a corporation because of the liability exposure that could occur and the protection that corporations provide. If you have employees, including yourself, self-employment tax savings. S corporations are great about that, and I'll talk about that a little bit later. And then again, going back to branding, people take you more seriously as a corporation, at least in my opinion. Again, I've been doing this for a while, so I have my own thoughts on that. But I think of corporations as helping your business on the marketing side. And this is when I meet with new clients that are setting up a business, it's not basically I'm going to do this and I'm going to stick that way for the rest of my business's existence. There's actually a natural progression of how this works. Usually most people start out with a sole proprietorship. Then they move into the LLC and then go to the S corporation. The sole proprietorship stage, I like to call it the light bulb stage. That's where you get the idea. All of a sudden you go, ping, you get this great idea, I want to do this. So then you can start planting the seeds about how to get started on this, and you say that, okay, I decide that I want to do something about this. It's not just an idea anymore, I want to do something with this. So then you decide that, okay, so I'm just going to start testing the waters, see if my business idea can take form, shape. That's really where the sole proprietorship starts. Then with the LLC, that's what I call the Chicken Little stage. Basically, the sky is falling, the sky is falling. That's when you start worrying about liability exposure. You're worried about, oh my God, I'm doing business now. I got all these vendors, I got all these clients, all these customers. I'm worried about getting sued. And that's where you start thinking about liability exposure. Your personal assets getting exposed to the liabilities of the business. That's when people start thinking, I want to have that sweet, sweet liability protection that an LLC may be able to provide. So we set up an LLC for them. But then as time goes on, the business is doing well, and eventually it gets to the point where it's actually doing really, really well. And then we might want to start thinking about a sub-factor S corporation. And when I recommend sub-factor S corporations because they provide one tax benefit that's not provided with a general LLC without an election. Sub-factor S corporation let me go back. With an LLC, provided you don't do anything else, all the income that the LLC generates is subject to self-employment taxes. So if you make $1 or $500,000, all that income is subject to self-employment taxes, and that could be up to 15.3%. So in addition to all the income tax that you have, you could be subject to 15.3% of payroll taxes. Now, a lot of my clients say that I don't want to pay all of that. So what we do is we make them a subchapter S corporation. Well, in that case, the owners, the president, I actually did an employment agreement for one of my subchapter S corporations that I founded. I gave my client an employment agreement. She is the president of her corporation, provided that she pays herself a salary as president, doing the job of what a president of a business does in that industry does, a reasonable salary, and you could justify that salary to the IRS. Say, for example, it's $45,000. Only that $45,000 is subject to self-employment taxes. Now, if the corporation makes $100,000, that it's all income taxed, but there's no self-employment tax on that $55,000, which is the difference between the $100,000 and the $45,000 that the owner is paying herself as a president. So you can still take the money out of the corporation, but that's not as salary. That's as a distribution / dividend to a shareholder. But that $55,000 is not subject to self-employment taxes, which is why a lot of people decide to take that route, and they decide to elect to be taxed as a subchapter S corporations. And I said that LLCs can be taxed as LLCs can elect to be taxed as a subchapter S corporation, and up until 2015, that that usually was the case, because it was really kind of hard to convert a LLC to a corporation under Washington law. What you had to do is actually form a new corporation and merge the LLC into a corporation and then actually become a corporation in order to get additional liability protection. But if people decide now, after 2015, Washington changed this law. So now it's actually, you can convert your LLC to a corporation. So my idea and my recommendations is that if you are an LLC and you want to be taxed as a subchapter S corporation, why not be one legally? Because again, corporations under Washington law provide much greater liability protection than an LLC. And corporations used to be a lot harder to do. Now with the new conversion statute, they're relatively easy to do. Don't even have to change your EIN number. Really the biggest hurdle to overcome is actually changing your marketing, because you're no longer an LLC, you're an Inc. So now, if you look at the bottom of the slide, there is a danger. If you have an operating agreement and as an LLC that has partnership tax language in it, and you convert to a subchapter S corporation, you could invalidate the S election, which could lead to C corporation treatment. So, and that's actually, I found that out with one of my clients last year. They were an LLC for quite a long time, and then they converted to a subchapter S corporation status. They never changed their legal structure to a corporation until I did it at the end of last year. And if the IRS got wind of that, they could have invalidated their subchapter S corporation election from 5 years ago and treated all of their income earnings as subchapter C corporation income, which could have been disastrous for them. So if you do decide to convert from a LLC to a corporation and you have an operating agreement that has partnership tax language in it, get rid of it, or just convert straight to a corporation under Washington law.
Hey, Chris, got a quick question from one of our.
Yeah.
Oh, so Jim